Yes, Mr. Beacon.
I said I would move to ground 2. I will in just a couple of minutes. Two last points on ground 1. First relates to the clip of legislation that you have now in front of you.
Thank you.
I've identified the particular provision. 70I defines a short lease as one whose term is 5 years or less. So a 3-week lease looks like it's a short lease.
Yep.
70I subsection 10, page 3 of the clip, provides that where plant and machinery is the subject of a sale and finance leaseback as defined in section 221, finance leaseback is not a short lease if it otherwise would be.
Yep.
Page 5 of the clip, heading sale and leaseback, there are a series of provisions which make special rules for transactions where you have a sale and leaseback. The detail doesn't matter, but for present purposes it's sufficient to note that there is a concept of a sale and leaseback. There are particular rules for it. And the concept of a sale and leaseback is in effect defined by section 216 of section 1.
And your case fits directly in it.
Yes.
Yes.
Section 217 over the page is an example of a rule that applies to a sale and leaseback. Doesn't matter. Page 9 of the clip has the definition of finance lease. Finance lease is an arrangement whereby the equipment is leased or otherwise made available, which under generally accepted accounting practice would fall to be treated as a finance lease or a loan.
Yes.
Page 11 of the clip is the definition of sale and finance leaseback. It's this that renders our leaseback not short. So B is the buyer, S is the seller. B enters into a relevant transaction with S. After the date of the transaction, the plant and machinery, little one, continues to be used for the purposes of an activity carried on by S or by a person other than B who is connected with S, or 2 or 3. And then little c, it is directly or indirectly as a consequence of having been leased under a finance lease that the plant and machinery is available to be so used after that.
What's the relevant transaction?
That's actually in a provision that I haven't printed. But
Yeah, don't worry.
It's at section 213, it's the sale.
Yes. I assumed it was a sale. Yes.
Page 14 of the clip is an example of a provision that applies where you've got a sale and finance lease back. That's section 222. It's one of a number of special rules that apply to a sale and finance lease back. So it's an important concept in the code as a whole.
But it does illustrate that if plant or machinery is the subject of a sale and finance leaseback, the legislation contemplates that S may be required to bring a disposal value into account because of the relevant transaction.
Correct.
So you would say that demonstrates that it cannot be the case that simply because you are leasing back at the same time, the sale is not a disposal.
Correct. Now, I can't put it any higher.
You can't put it higher than that, and obviously this is, Mr. Milne doesn't just rely on the lease back, but on the other aspects of the transaction. But it does at least illustrate that.
Yes. It's consistent with my view of the world.
Yes.
And then page 17 of the clip, Your Lordship asked, how does the system give effect to capital allowances?
Oh, yes.
And it depends whether you're carrying on a trade or not, but where you are carrying on a trade,
It's given effect in calculating the profits.
yes, either as an expense or as a receipt.
Yes. And that feeds through to income tax or corporation.
Yes.
Yes. That's very helpful. Thank you very much.
The last point to make just on ground 1, point out it's in our skeleton, but I've forgotten just to draw your attention to, that we do say you discern the purpose of section 61(1)(a) from the words in context of the Act as enacted, because you're trying to discern the purpose of Parliament at the time the words were enacted. That's Boss Holdings, the Supreme Court decision.
And when do you say these words were enacted?
These words were enacted in 2001.
Yeah.
And just for your note, it's in.
And what does that cut out? What is the argument that you're trying to answer?
If the argument is that you can discern something about the purpose of Parliament in 2001 from the changes made to the code in 2006 or 2011, that is an impermissible exercise in discerning the purpose of the provision.
Yes, I see.
That's what Lord Neuberger says in Boss Holdings. It's in our skeleton argument, paragraphs 51 and 52.
It's not a very surprising proposition.
And it's dealt with in the Upper Tribunal in passing at paragraph 90.
Thank you.
So with those minor additions, ground 2.
Yes.
So the Revenue's new case, one has to assume that they've lost on ground 1. There was a disposal of the assets, and there was a lease and a repurchase pursuant to the put option. So the case then against me is, notwithstanding all of that, the requirements of 11.4 are not met, because either or both, the sum was not spent on the provision of the equipment, or the purpose of the expenditure was not wholly or partly for the purposes of the taxpayer's trades. I say both are wrong in law. Equally, in addressing the purpose element of ground 2, we have to proceed on the basis of the required assumption.
Yep.
And we also need to address the question raised in my lady's permission decision judgment at paragraph 38. I propose to do that as well.
Which is whether they can take the point at all.
Whether they can take the point at all. So I propose to proceed in 4 stages. One is the purpose of construction of section 11.4. Secondly, the relevant facts. Thirdly, the application of the former to the latter. And then lastly, the revenues case and what's wrong with it. So that first stage, purpose of construction, 2 relevant elements on the provision of. Wasn't clear from what Mr. Davey had to say yesterday whether he was construing on or on the provision of. For my part, at least for now, I don't see a relevant difference. So on the provision of and wholly or partly for the purposes of the qualifying activity, addressing on the provision of first, there is case law and high authority, both in this court and in the House of Lords, that the expression on the provision of encompasses amounts paid to construct or to acquire a capital asset, and that it can extend to other costs incurred, for example, in transporting or installing assets, but it does not extend, for example, to the costs of raising finance to buy the asset. One doesn't need to look at this exercise in detail, but this has the foundation in Berkeley Curl, which is the case about the dry dock in Glasgow. That's volume 1 of the authorities, tab 18, where the debate was, if you dig a hole to pour concrete in to make a dry dock, and we assume you get capital allowances on the dry dock, do you get capital allowances on digging the hole? House of Lords say 4-1 if you do, because that's on the provision of the asset. Benodico, House of Lords decision, authorities volume 1, tab 21, was the case about whether the finance costs, so borrow money to buy an oil rig, or build an oil rig, I forget, were the finance costs on the provision of the oil rig? Held no. It's Lord Wilberforce in Benodico who says that the expression on the provision of can extend to things like installing and transporting, but it doesn't extend as far as finance. Those authorities are well summarised in the judgment in this court by Lord Justice Nugee in the case of Inmarsat. It's a case about the cost of putting satellites into orbit. Volume 3 of the authorities, tab 47, and it's his lordship's paragraphs 58 to 66. But we know that at least on the provision of extends to the cost of buying the equipment. Perhaps that's not such a surprising conclusion.
Was the cost of putting the satellites in orbit part of the costs of?
It was.
Yes.
It was akin to the cost of installing the asset.
Or transporting.
Or transporting. Because the evidence in that case was that a satellite on the ground is a beautiful
It doesn't do anything.
collection of shiny assets, but it doesn't do anything. It's only valuable in orbit. And so the court finds or upholds the Upper Tribunal in finding that was a cover. So pausing there, given that we know that it's designed to extend to the construction of the acquisition of an asset, what is it here that would prevent on the provision of being satisfied? Like, what other meaning is there of the phrase or term? Now, my learned friend relies quite heavily on the case of Tower M cashback as requiring some different analysis. Tower is in volume 2 of the authorities, tab 36. The debate in Tower was the 100 spent on the software, and the software was probably, to use the illustrative numbers, only worth 25, and the 75 went round in the loop so as to fund the purchase of the software at the ostensible price of 100. Lord Walker in the Supreme Court came to the conclusion that on the facts in Tower, that was not the right analysis. And if you ask the particular statutory question, what was this money spent on? Only the 25 was spent on the software. And it would just be helpful to turn that up quickly. So it is volume 2, tab 36. And it's in particular Lord Walker from paragraph 66 onwards. It's page 576 of the bundle. Paragraph 66 under the heading Discussion and Conclusions, His Lordship says this: I start from the Special Commissioner's findings of fact summarised in para 55 above, and then my Lord, in the first instance, accepted 1, not a sham but preordained, and 5, no commercial purpose for the insertion of the banks. My Lord did not agree with 6, the Special Commissioner's rejection of his third approach. And as to 4, prospect of repayment of the loans, I need to read that. And then the judge strongly disagreed on 2, valuation, and did not mention 3, disposition of valuation of rights to software in bits. And then His Lordship Lord Walker goes on, before disagreeing strongly with the Special Commissioner's views on valuation, my Lord Justice Henderson stated that the market value of the software was completely irrelevant. That is, in my view, putting it a good deal too high. He said at the foot of that page, I cannot accept that the questions of valuation was totally irrelevant in the context of a complex preordained transaction, where the court is concerned to test the facts realistically viewed against the statutory text purposefully construed. He deals with what my Lord had to say on the first appeal, but then if I pick it up at para 72, page 578, for these reasons, I respectfully consider the judge, although correct in his view that market value was not determinative, and also correct in thinking a Special Commissioner had used unnecessarily colourful and contradictory language, was wrong to dismiss as sweeping as he did Special Commissioner's scepticism about the valuation of the software rights and the commercial soundness of the transactions. Driven by the facts. And then turning over the page at 579, some stage coming back to the court to read doesn't need to be now, from paragraph 75 through to the end of 80, because it's here where Lord Walker identifies the particular requirements of the legislation there, which was that you had to incur the expenditure on a capital asset that was software. And he tests that against the facts in that case in order to discern whether the 100 was spent on the software or only 25. And the gist of his conclusion, which leads to his answer, page 579 of the bundle, letter E. In this case, there was a loan, but there was not in any meaningful sense an incurring of expenditure of the borrowed money in the acquisition of software rights. It went into a loop in order to enable the LLPs to indulge in a tax avoidance scheme. And he says at 77, one of the lessons of Barclays Mercantile, it's not enough for the revenue in tacking a scheme of this sort to point to money going round in a circle. Closer analysis is required. And in Barclays, it didn't make a difference. And then page 580 of the bundle, just below letter B, in the present case, by contrast, the borrowed money did not go to M cashback even temporarily. The answer in Tower as to whether the money was spent on the software was driven by an analysis of the nature of the borrowed money that was the product of the loop, the ostensible payment of the purchase price of 100. And the court was able to arrive at that conclusion in part because the software was not worth 100. It looked like it was only worth 25.
And the money didn't go to the vendor.
And the money didn't go to the vendor. It was paid by solicitor's direction. But for our purposes, it's the judgment of Lord Hope that has more general applications. That begins at paragraph 81, page 581. Can I invite you to turn to 582, heading the expenditure issue. Paragraph 86. He says at letter C, the general rule itself is not in doubt. Expenditure is qualifying expenditure if it's capital expenditure on the provision of plant or machinery, wholly or partly for the purposes of the qualifying activity, 11.4. The problem that the facts of this case give rise to is the extent to which surrounding circumstances, such as the source and destination of the funds expended and the commercial soundness of the transactions when looked at as a whole, may be taken into account in assessment of the question whether the taxpayer was involved in expenditure that entitled it to the allowance claimed. He desses the facts, but picking it up at paragraph 87, letter F, the reality, however, was that much of the consideration paid by the LLPs for software was derived from funds borrowed by members of the LLPs on non-recourse terms, which was immediately passed back by way of chain of banks to the lender. Towards the end of that paragraph, again citing from Barclays Mercantile, Lord Nichols, the question is always whether the relevant provision of the statute, upon its true construction, applies to the facts as found. At 88, section 11.4 sets out the general rule that expenditure must satisfy if it is to be qualifying expenditure. Purposively construed, it requires it to be demonstrated in this case that the whole of the claimed expenditure of 27.5 million was actually incurred on acquiring rights in the software. This is a factual inquiry, the extent and depth of which will always depend on the circumstances of each case. It goes on to conclude on the facts, in agreement with Lord Walker, it wasn't the expenditure of 100, it was in effect the expenditure of 25. He arrives at that conclusion in particular for the last 5 lines of paragraph 89. A significant part of the money that was passing from one party to another in this case was returned to its source immediately. As Lord Walker points out at paragraph 76, it did not go to M cashback as payment for the rights in the software, even temporarily. This suggests that it is, to say the least, questionable whether it was expended in their acquisition at all.
That's all analysis, and I was just looking back at the facts as found at 55. The base facts were not the same thing as the Supremes ended up deciding in terms of the analysis. So there is quite a neat illustration in this case, isn't there, between what you might call the primary facts and the legal analysis based on those facts as to what was paid for what.
What was paid for what is a conclusion that the Supreme Court arrive at. But they can only arrive at that conclusion, Lord Hope says, in light of the facts as found.
Indeed. So you look back, I mean, there may be more to it, but you referred us earlier to paragraph 55, where the base, what I would call all the primary facts are set out.
Yes.
And what I would observe is that where the Supreme Court ends up in terms of its analysis has travelled quite a long distance away from what the primary facts were to an analysis based on those facts about what was paid for what. Okay. So they split it 25-75. They talk about part of it going round in a loop, and that's not what's paid for the intellectual property or the software. It's only 25% that's paid for the software. I didn't see any of that reflected in the primary fact finding at paragraph 55.
Well, finding 2, the market value of the software was materially below the price ostensibly paid. The 75-25 split comes from the Special Commissioner's finding recorded in paragraph 56.
Yep.
And the fact that the monies went in a loop and didn't rest with the vendor is a feature of both paragraphs 55 and 56. So I wouldn't accept my lady's first formulation that the Supreme Court have relied on different facts or drawn their own inferences.
No, I suppose my point was more, and you may say that even this isn't justified, that they have taken the primary facts and invested them in an analysis of what the tax consequences should be of those primary facts.
I put it the other way around, that they've discerned the requirements of section 11.4 and section 71,
yep.
And they have then discerned what facts are relevant in deciding whether you have or have not met the requirements of section 11 and section 71.
And they decided that to an extent you have, and to an extent you haven't.
They decided on the basis of the split that the Special Commissioner had found that was satisfied as to 25, but not as to 75.
Yeah.
But they are doing this on the basis of the facts found.
Yep.
And Lord Hope says on the provision of is a factual inquiry.
Absolutely.
So that is an example in the context of section 11 and section 71 of a careful analysis of what the statute requires. Here we say what it requires is the acquisition of the relevant equipment. So what you've got to ask, is that what you spent the money on? And did you pay the money for the purposes of getting that equipment for use in your trade? Just one other paragraph I ought to show you. It's paragraph 93, Lord Hope, referring back to Mercantile. The House of Lords adopted a practical commercial approach to the reality of the expenditure. Although the facts of this case lead to a different result, I would adopt the same approach here. As Lord Walker's exacting analysis has shown, they do not support the LLP's case that the whole of the claim software was actually used to acquire the rights in the software. All of the claimed expenditure was actually used to acquire the rights in the software. I agree that in the circumstances of this case, we can and should reach our own conclusion as to the amount that should be allowed in respect of the claimed expenditure. They're doing that on the basis of the finding made by the Special Commissioner. So Tower throws some helpful light on the factual inquiry required on the provision of. The interpretation of the other part of 11.4, namely it has to be for the purposes of the trade. Purpose in this sense involves looking to the intention of the payer and the subjective intention of the payer in making the payment, because it's the purpose of the expenditure that you're concerned with. Why did the payer pay it? And that is said in Vodafone to be a question of subjective intention. It would be useful quickly to turn up Vodafone. It's the first volume of Authorities, tab 28. It's at page 742 of the report, which should be page 351 of the bundle. This was a question about whether something was wholly and exclusively incurred for the purposes of the trade, so it's not quite the same statutory provision. And what Lord Justice Millett has to say begins at letter B, but then passage often quoted in later cases begins at letter E, which sets out a series of propositions. So I just write you quickly.
Sorry, can you give me the page reference again?
It's page 351 of the bundle.
Okay, I'm here. Okay, got it.
Between letters E and F,
Got it. Yep.
series of propositions. Perhaps rather than me read it out, if I can just invite you very quickly to read that long paragraph, beginning the leading modern cases. That's proposition 4. I know from Mr. Davey wants to rely upon. What Mr. Davey says is, well, if you look at proposition 4, your subjective intentions can include some subconscious motives where the inevitable consequence of what you're doing must be taken to be something that you intended. What's interesting about that passage is his lordship there is not saying you look at the subjective and the objective. He's not saying subjective is not determinative. 4 begins by reiterating that subjective is determinative. What he's saying is that in discerning the subjective intention, you may have cause to add in something that the individual must have intended.
I always found that rather difficult, I have to say, conceptually. I mean, subjective to me means something you're conscious of.
Yes.
And frankly, this is just a mixture of subjective plus a degree of objective considerations.
Yes.
It's a reference to Melody, isn't it?
It is. With all the thought in this Melody of getting a deduction for her dark clothing.
Where the special commissioners had accepted her evidence that all she thought about was the requirements of the profession, and the House of Lords said, but she must also, whether she thought about it or not, have had the need to be clothed for decency.
Warmth and decency, I think.
For decency in mind. Well, not in mind. That must also have been part of her intentions. But it is, as my lord says, it's a bit of a mixture of what's subjective, what's in your mind, what's conscious.
I accept that, accept and endorse it. But the way his lordship does it is not to say it's subjective and a little bit of objective, or subjective is not determinative.
It's things that you must have intended, even though you didn't realise you intended them.
They fall under the badge of subjective intention,
Yes.
which is determinative. Now, that might matter here because we have the required assumption in our favour that the subjective intentions were to buy the kit for use in the business.
Where do we find the wording of this required assumption?
It's in
It's in the
The
core
order.
bundle in the order of the court, is it
in
not?
the order of the court. I think it should be tab 10, core bundle, pages 112 and 113.
And we amended that to, we'll assume that when the bank exercised the put options, the subjective intention of
The
taxpayers was to reacquire.
Yes.
Doesn't exclude other unconscious or conscious motives, does it?
Well, my starting point is, by implication, it was designed to exclude subconscious. It's a statement of what the subjective intentions were.
Does it mean that was their only intention?
It leaves that entirely unexpressed.
The point of it was to rectify the prejudice that you might have had. So all it's doing is saying we're going to give you the benefit of, as best your evidence, that you didn't have the opportunity to call because you didn't know it was going to be alleged, because you didn't know this was going to be part of the appeal. So we're going to remove the prejudice that could have been caused by that and give you the benefit of such finding by the court as it might have been at its highest, which is that we accept your evidence as to a subjective intention. That's all this does.
But even that formulation doesn't quite answer my Lord's point as to whether it is to be assumed that that is the only subjective
No,
intention.
I mean, it does, because the answer is no, that is not to be assumed, because it only goes as far as the order was, and the purpose of this order was to remove any prejudice from you not being able to call evidence at first instance.
Well,
So everything else is up for grabs.
the highest our evidence might have established was that this was their sole intention.
So the highest your subjective evidence of subjective intention could have demonstrated is what was the subjective intention of your witnesses, whoever you cared them to be, not what one might think might be the unconscious, the consequences which are so inevitably and inextricably involved. So in other words, it wasn't excluding, it couldn't possibly be taken to exclude four of Vodafone. That was the point of it.
Difficulty in quibbling with your ladyship,
Is that
might have
I-
been your ladyship's drafting.
Well, yes, but it was after a long hearing, if you recall, a long, hot hearing, and we could all traipse through the transcript or look at the film again. But that it was Lord Justice Nugee who proposed it as a way of rectifying or levelling the playing field, making it okay, and dealing with any prejudice.
Yes. First submission here is that is to be read as our sole subjective intention. And if that's right, then we don't need to contemplate any subconscious intentions because we have the answer to the subjective intention. If I'm wrong about that, you have to add in what must have been intended. Then I say that what must have been intended was the reacquisition of the equipment for use in the business. You don't need to go any further than that. So the objective inevitable consequence is the same as the subjective intention as expressed. If I'm wrong about that, you've got to add in some other unexpressed inevitable consequence. The candidate offered by Mr. Davey yesterday was, well, they did this in order to get the allowances. But that is both not inconsistent with a subjective intention of buying the equipment to use it in the business. Doesn't prevent the statutory test being met, but equally it's in grave danger of proving far too much. You're being asked to address here the meaning of section 11.4 in any circumstance. What you say about 11.4 applies to everybody who incurs expenditure, capital assets. So if an unexpressed motive of wishing to qualify for the allowances is sufficient to prevent the requirements of 11.4 being met, you leave taxpayers in a position of only qualifying for allowances if they buy ignorant, only qualifying for allowances if they buy ignorant of the availability of the allowances.
You're going to have to unpack that one for me a little bit, I'm afraid, because I'm not sure I've quite followed that point.
The case against me at its highest, as I discerned from my learned friend yesterday, was to say that you can't fail but to take account of the inevitable desire on the part of these taxpayers to qualify for the allowances when they repurchase the kit. Now, my first answer is that that doesn't prevent a conclusion that they did buy the kit for use in the business. It's not inconsistent. My second answer is that if that is said to be a disqualifying feature, then it has to be a disqualifying feature for any person who incurs expenditure where section 11.4 is an issue. And if wanting, consciously or unconsciously, the benefit of the allowances when you buy the kit is sufficient to mean the requirements of 11.4 is not met, then you would only be able to qualify for allowances as a taxpayer if you bought an asset ignorant of the availability of the allowances. So the ignorant taxpayer would qualify.
Okay, I get the point that you make. I had it in mind from the Commission hearing and indeed from yesterday, and maybe right, this is going to be a tax made against you, but it was much more to do with whether we as a panel could take into account the findings, for example, para 75 of the tribunals, the FTT, where they say that the purpose looked at compositely was one of tax avoidance, and it was how that stood next to. You maybe, I mean, I'm sure you're coming on to that, but
I'm going to come to
okay,
that.
well let's fine. Thank you very much.
On Vodafone and what Vodafone means.
I just have, I suppose, just to plant. I see all your arguments on Vodafone. I'm having a little bit of difficulty putting them into the system at the moment because what we have looked at is putting them into the Ramsey lens, because the Ramsey question is whether, put in very bald terms, and forgive me if I stated a bit baldly, Ramsey says, the question under Ramsey is what's the sort of breadth of what's the scope of what I look at when I'm construing this piece of legislation?
Yes.
How do I work out what the fact pattern is that this particular piece
what are the relevant facts?
the relevant facts for this piece of legislation?
Yep.
And I am just not entirely sure of your case of how subjective intention feeds into that analysis.
I'm going to come to that.
Thank you.
I broke off the moment of just dealing with the consequence of the required assumption.
Yep.
Last piece of that little jigsaw is my friend relied on my law's decision in a case called 7 Individuals,
Oh yes, I remember.
where there was a statutory main purpose test. And the taxpayer's argument, this is section 74ZA, taxpayer's argument was, well, that's the subjective intention test. And Mr. Morm for the taxpayers pointed to Brebner, which is the House of Lords case, which appears to say purpose is about subjective intention. And what my lord tentatively said,
I didn't have to decide it, if I remember rightly.
the paragraph I invited my own friend to invite you to read, paragraph 107,
Yeah.
says, I don't have to decide this. So the point was left open. But your lordship's tentative view was that maybe Brebner and purely subjective intention might not be right, at least in the context of that statutory main purpose test.
It was partly to do with the way it was drafted.
Yes, it was all about what your lordship, the point your lordship makes is that you may have to look to the purposes of the advisors or people who stood behind the scheme,
Yeah.
given the way the statutory test was drafted. So I would respectfully say that your Lordship was wrong to suggest a departure from Brebner, but you didn't decide it. But even if your Lordship was right about that, it was right in the context of that statutory provision. It's not a generally applicable approach to the notion of subjective intention.
The difficulty was, it's coming back to me now, the statute was drafted on the basis of what are the purposes of arrangements.
Yes.
And that immediately raises a question, because purpose tends to be somebody's purpose, but arrangements aren't a person, they're a thing.
Yes.
That's what raises the question.
Yes.
And you say that doesn't apply here.
Even assuming your Lordship's direction of travel is right, as I often formally say I don't accept, but even if it is right, it just doesn't apply here.
Yes.
So that's 7 individuals. Last point, where we're thinking about the scope and operation of section 11.4, to what extent on the provision of question or the trade purpose question is a tax motive relevant? And we know from BMBF, in particular paragraphs 38 through to 41 of Lord Nichols, that the motive of generating the allowances on the pipeline was not a material factor. And we have paragraph 51 of Rossendale saying again that the ability of the court to conclude there about the application of the rating legislation was not driven by the finding about the motive of the parties and of the arrangements. So the second stage of my exercise, what are the relevant facts? Well, here, this is capital expenditure, that's common ground. Taxpayers did use the assets throughout in their qualifying activities, their trades, that's common ground. Prior to the exercise of the put option, the taxpayers did not own the assets. That's a consequence of Malone and Friends being wrong on ground 1, whereby they have to accept there was a disposal and a lease and a termination of the lease. It's also necessarily a product of ground 1 that absent the exercise of the put option, the assets would have belonged to SocGen. We also know that the taxpayer's subjective intention in paying the price under the put option was at least to reacquire the assets for use in their trades. That's the required assumption. We also know they paid the appropriate price for the assets, the FTT at paragraph 292 sub 3. So what my learned friend wants to add to that list of relevant facts is the fact that this repurchase happened a short period after the original sale. But I say that's not a relevant fact for the purpose of section 11.4. 11.4 doesn't ask, are you incurring expenditure on buying an asset that you have recently owned? It's not material to the on the provision of question or the purpose question. Well, if it also wants to add in as a relevant fact, that the transactions as a whole were tax motivated. I say that's not material, not a material fact. I'll see Rossendale. And of course, it's also important to bear in mind, before I come to my lady's question, that all of the findings of fact that Mr. Davey relies on for the purposes of his section 11 arguments were found in the context of a section 61(1)(a) argument, where the debate was about loss of ownership. no findings of fact were made in the context or in the knowledge of a Section 11 argument. So that takes me to perhaps the next point of principle, which is my lady's paragraph 38, commission
Yeah.
decision question.
Yeah.
We do not say that there is a reason of logic or conceptual priority or principle. There is no such reason why this court cannot apply a Ramsey purposive construction approach to a statutory provision when such an argument was not made to the first tier. Do not say as a matter of absolute logic or other principle you can't do it. But I do say that in doing that exercise, it can only be in light of the findings of fact that were made by the FTT, in the knowledge that those facts were found without sight of the benefit of this argument. One needs to be wary of relying on a particular finding of fact directed at a different argument before being satisfied that it can be relied upon for the purposes of a different argument. So what Will Frank can't do is in effect invite you to draw inferences of fact that could and should have been the subject of an invitation for the first tier to draw. Now, the third of my four stages, applying the purpose of construction to the relevant facts. Here, in law, the taxpayers were not owners of the equipment at the end of the lease. They became owners on the exercise of the put option. They paid the relevant sums to SocGen, who were then the owners, and they did so for the purposes of getting the equipment for use in their business. As a matter of contract, as a matter of law, the price paid was consideration for the equipment. We know the proper price was paid for the equipment. The taxpayers were not paying for the equipment and something else. So this is not a tower case. So in our submission, the taxpayers paid these sums to acquire the equipment for the purpose of using the equipment in their business. And on those facts, there is no doubt that the requirements of Section 11.4 are met. Now, we know that the first tier tribunal found as a matter of law that there was an effective purchase on the exercise of the put option. That's paragraphs 52, 67 and 312 of the FTT's decision. But we can actually go further than that. And here it would help to turn up the first tier decision. Because the first tier have made findings about the requirements of Section 11.
Can I just pause you there, please? Press pause. I'm looking at paragraph 15 of Rossendale. Are we agreed that the first stage is open to this court? In other words, to ascertain the class of facts which may or may not be transactions intended to be effected or to fall within to amount to an acquisition for the purposes of section 11.4. That is an exercise which this court is entitled to do because it's an exercise of law.
Yes.
Yes. So we can all agree that was the question. That was as my Lord Justice Nugee put it yesterday. So that part is, we all agree we can do that. We can construe the statute.
Yes.
The second is to discover whether the relevant facts fall within that class in the sense that they answer to the statutory description. So that's what we're looking at now. Your submission is that the only facts that we can look at are the assumption, the required assumption, which is a fact, and then there's a debate about, you're about to go into the FTT, the extent to which we can look at other facts as found, for example, the paragraph 75 facts. But that's really the issue, isn't it?
Well, my point of principle in answer to your ladyship's para 38 question was,
This is the para 38 question, isn't it?
I can't say you can't do the first exercise because it's a matter of statutory construction. But I can say that when you're doing the second exercise, you have to address only the findings of fact made by the first tier tribunal.
Thank you. So I think that does really, yeah, okay, that helps me greatly on paragraph 38. I think there's a much more commonality now than there was, I think, when we last debated it.
If I put it colloquially, your ladyship was asking, there's a sort of a logically prior question, which is, can this court look at a new Ramsey argument?
Yeah.
Where it wasn't considered below?
Yeah.
Having thought carefully about it,
Yeah.
I don't think I can say you can't do it.
Good, but I mean, that helps enormously because that, I have to say, was where I certainly was headed, is that so far as it's a matter of law, and construing a statute must be a matter of law. So the first bit, first stage, must be open to us.
Yes.
But everything turns on the second stage, doesn't
The
it?
second stage is you're limited. If the first year have found facts 1 to 10, you are limited to facts 1 to 10.
Subject to argument. So you say Tower is a different case. I mean, that's why Tower is quite an interesting case because we had findings 1 to 10, and then you look at what the court actually did with it. And
I say
I've got your submissions on that.
So
So it's all
the
different.
decision in Tower rests on the court looking at facts 1 to 10. But even doing that exercise of looking at facts 1 to 10, this court has to be wary to ensure
Indeed.
the procedural
Yeah.
fairness that is baked
Got
into the
that
Commission
entirely on
decision,
board. Yeah.
that you need to be very careful
Yeah.
about the weight you put on a given fact that wasn't found in the context of the present
Yes, so we mustn't transpose facts that are limited to one context to the different context under section 11, unless it's fair to do so. So, I mean, that's, again, I suspect we'll hear
there's a built-in guardrail of procedural fairness.
I think we've got that one in mind. Yeah.
I mean, if your absolute proposition, which I think you rightly disavow, were correct, it would mean Ramsey itself could never have been decided.
And there are plenty of instances, if one reads the case law, of a Ramsey argument being run in a
Popping
slightly...
up later. I think Ramsey.
Not least tankers, where it was never part of the revenues case until Lord Temple had introduced it in the House of Lords.
Yes, I vividly remember that.
Yeah.
Yes.
So that absolute stance I can't adopt and I don't.
Thank you.
But once one does this exercise on the relevant facts, I say 11.4 is met. But the point I was about to make is we can actually go one step further. So first tier decision, paragraph 296. This was in the context of Mr. Milne's argument that there couldn't be double duty done by the option price. So it's core bundle tab 20, para 296. What Mr. Milne said was, it can't do double duty, and because it satisfies section 11, it can't be used again in QE minus QA. 296 sub 2 records is Mr. Milne's submission. And then 5 lines down, at this stage of the analysis, HMRC are proceeding on the assumption their Ramsey argument is not accepted. So that's about 61(1)(a). On that basis, the better view is that on paying the option price as consideration for the relevant assets, for the purposes of section 11, the appellants incurred qualifying expenditure of that sum. It cannot be said, therefore, that the appellants guaranteed that SGLJ would receive the option price. So Mr. Milne's case was, because you meet section 11, you can't do double duty. That's reiterated in 297 sub 1, Mr. Milne's submissions. As noted in HMRC's view at this stage of the analysis, the better interpretation is that given that it was always the intention of the assets to end up back in the hands of the appellants, the option price constituted only qualifying expenditure within the meaning of section 11. So the case against me then was, you meet section 11, but you can't count it again in QE minus QA. So then we turn to paragraph 312. We're now in the first tier's decision. The judge begins, however, I cannot see any viable basis for the revenue's view that A, if the option price constitutes qualifying expenditure for the purpose of section 11, it cannot also be brought into account in QA for the purpose of section 70E, or B, if it's brought into account in QA, it cannot constitute qualifying expenditure for the purpose of section 11. And what the judge concludes in subparagraphs 1 and 3 in 312 is that the requirements of section 11 are met. In particular, it's the last 3 lines of 312.1 and the whole of 312 sub 3. So what the first here is doing there is rejecting the double duty argument from the position that the requirements of section 11 are met. And the first here arrives at that conclusion notwithstanding all of the other findings that are made about the tax motivation here. The judge rejects the revenues issue 4 argument on the basis that the requirements of section 11 are indeed met.
Can you help me with the last bit of sub 3, 312 sub 3, which is the caveat the judge seems to rely on to the effect that she talks about looking at the bigger picture as part of the analysis, applying a Ramsey composite approach as set out above, which of course wasn't before her. So isn't she dealing with a very technical sort of, well, help me, what she means there.
What she's saying there, as we understand it, is the revenue had a wider Ramsey argument about what's now our ground 1. And she's looking at this issue in a world where the revenue are not successful on that ground 1. And she's saying that once you recognise that, it's not maintainable for the revenue to argue that the requirements of section 11 otherwise met are somehow not met. And that aligns with the last few lines of subsection 1 in that paragraph 312. Good. Mr. Milne's thesis at this point was, even if I'm wrong on issue 1, you can't have a number that does double duty. And his thesis was, well, you are in 11, so you can't count it somewhere else.
I can see all of that, but yes, that,
What the judge says is,
that's gone away.
that's gone, you are in 11.
But what's come in now is a new argument on 11.
No, but what she's there rejecting in 3, I cannot see any justification for concluding that where its requirements are otherwise satisfied, the requirements are otherwise satisfied, Section 11 is not intended to operate where a lessee repurchases an asset under agreement to also happens to operate as a guarantee of any residual amount for the purpose of the funding lease regime. I also cannot see that the revenues argument the requirements of 11 are not satisfied viewing the bigger picture can operate otherwise than as part of the analysis applying a Ramsey composite approach I've set out above, which at this stage of the analysis she's assuming she's wrong to support.
Well, she might be, but anyway, it just reads to me a little bit like what she's saying is the only way with it that you might look at Section 11 differently if you were applying a Ramsey lens, which is exactly what we're now being asked to do.
But I don't.
You don't agree? I mean, I've got the point. I don't think you accept that.
I don't, because the argument that we're now addressing wasn't before the judge.
Quite so. Quite so.
So she is here addressing the arguments that were made.
Mm-hmm.
And she finds that the requirements of Section 11 are met.
Yep.
One needs to think about the procedural fairness of this. Am I to be deprived of my clients to be deprived of a fair appeal by a particular reading of a particular half sentence in the decision that wasn't addressed to the argument you're now addressing? Where ostensibly she decides this Section 11 question in my favour. This would all be different. If the revenue had run different arguments in the first tier, we may well not be here. At least the arguments would be different. So it is highly significant what the first tier actually decided. So what's wrong with the revenues case? My last of my 4 stages. You have my submissions. I think they misread and overstate the significance of Tower. They overstate and take out of their proper context the findings of fact made by the FTT in relation to different arguments. They fail to give effect to the decision of the FTT on Section 11 itself. They are not paying proper attention to the significance here that they've lost on ground 1. And it's not enough from a learned friend to say at a high level of generality, would Parliament have intended allowances to be available in these circumstances, where they no longer pursue ground 4, issue 4. So you are in a world in which the amount does double duty. The Upper Tribunal say that's the right answer as a matter of principle, for the reasons that they give. There is no appeal from that decision. More fundamentally, asking that very high level question doesn't descend to the particular requirements of Section 11 itself.
Mm-hmm.
Now, my learned friend had an example yesterday of somebody with a new milk float and a second milk float, and I think a third milk float. And I confess, even having read the transcript, I'm not quite sure which milk float we were talking about. But for our purposes, that example doesn't take the matter any further. He was using it as a I think, a precursor to a debate about his military spending example, and one looks at the purpose. But what is noticeable is that both my friend Mr. Milne and my friend Mr. Davey were asked by my Lord Justice Nugee yesterday, what was the relevant construction of section 61(1)(a) and section 11(4) that they were advocating, which these transactions did not meet. We do not find in the transcript from yesterday any proper answer to that question. Each of my own friends said, in effect, there's no need to identify a particular construction or interpretation which a purposive approach requires. All that matters is that whatever the proper construction, the taxpayers can't meet this undefined test. And that's not good enough, we say. Mr. Davey put it slightly differently. He said yesterday, well, you can just decide the role the provision has to play and then consider whether these taxpayers can meet that role. But again, it's all far too vague. Try and pin it down, it's like grasping at smoke. What you've got to do is to turn to the statutory language. And under a degree of judicial probing, my learned friend was prepared to accept that it would be a fair question to ask, why did they pay it, or what did they pay it for? And if that is the statutory interpretation that the Crown favours, then the answer here is obvious. We paid the money to buy the equipment to use it in our business. A couple of other points. You were shown the delivery mechanism by which you transfer chattels, or at least you transfer chattels in Scotland. Which law is slightly different. You have a contract for sale. These are chattels. You need some mechanism to record delivery. The process you saw of listing the assets and providing for there to be a delivery certificate is bog standard in commercial transactions dealing with chattels. And that's a perfect example of my learned friend trying to get this court to draw some adverse inference from the documents that was not drawn by the First Tier Tribunal. You were also shown the accounting advice, where the aim of the exercise was the same, to invite you to draw some adverse inference that the First Tier didn't draw. But the accounting advice records that if you have a lease back on certain terms, it won't be regarded as involving the disposal of the asset by the seller in a sale and lease back. And that's because the accountants regard it as a loan. So the fact that under the terms of a sale and lease back, the lessee is regarded as holding the risks and rewards of the asset is an accounting conclusion, perfectly understandable. But the Tax Allowances Code doesn't work by reference to the accounting treatment. Prior to 2006, it looked to ownership. After 2006, it asks, are you a lessee under a certain type of lease? But neither of those questions are answered by looking to the accounting treatment, once you know it's a finance lease. So the fact that this asset remained on the balance sheet of these taxpayers is true, correct as a matter of accounting practice, and irrelevant. My Lord asked, what happens if there was an asset subject to write-off?
There are provisions which deal with it.
There are provisions that deal with it, yes. Yeah. It's the total loss payments, and so if there's a total loss, you don't buy it back under the put option.
Yeah, but you still have to pay for it. So the risk does lie with the lessee.
Yeah. Now, well, also, Mr. Davey put it yesterday that, well, you didn't need to buy the kit because you had it at the outset. In one sense, that's true. It's the wrong question. To ask the question, did you need to buy this kit back in a world where you have sold it and the lease has come to an end? The answer is yes. That's my last 2 points to draw those threads together. Firstly, we say that there is no purposive construction of section 11(4) which would prevent the provision being met where the taxpayers acquire assets not then owned by them, so as to use those assets in their business. Allowances are available at this point of the debate in section 11.4 is the right answer in principle. And so in effect, once the Crown here have lost their Ramsey challenge on ground one, while it is open to this court to contemplate a different Ramsey argument on the facts, it cannot here lead to a conclusion that the requirements of 11.4 are not met. To reiterate a point I made just before 1 o'clock, the court may well then be left thinking, well, this is a rather odd result. That is primarily a product of the arguments that the commissioners chose to run, the arguments they've not pursued, and the particular requirements of a complex code worked in large part by reference to statutory algebra, where that code did not work perfectly for a period. Recognising the ground 2 argument is new, it's not a question of discerning whether the Upper Tribunal were right in law or wrong. You have to form a view about it as a matter of law. I invite you to conclude that ground 2 is not right as a matter of law. Unless there's anything else I can help you with, those are my submissions.
No, thank you very much, Mr. Speaker.
Please see my orders, my lady. I'll try and
Yes.
be as quick as I can. I think I've got 7 or 8 points in reply to Glenn Peacock. He opened his submissions, as if I heard him right, by saying that these were transactions by way of short-term financing, which were designed to produce capital allowances. With a great respect, that's exactly what they weren't. They were not financing at all. There was no financing involved there, as Judge Morgan found on numerous occasions. I needn't take you to it again, but for your note, paragraph 70, 73, 75, 265, 266, 267, 272, all confirm that there was no financing involved here at all. There was a little example put forward by the Crown during the hearing, which showed that there was a small amount of money that they had for a period of time that produced an interest rate of something like 15%, which certainly at the time was an enormously high percentage, but it was only a tiny figure anyway. So the finding of Judge Morgan was that this was not a financing, short-term or otherwise. It was purely a transaction designed to produce extra capital allowances. Secondly, I think my Lord Justice Henderson was asking about the bank's fee, and it's the Wiseman one, which is recorded in the first tier tribunal's paragraph 60, where the first fee on entering into the scheme in the first place was £170,000, but only if the bank exercised its put option, it got a £320,000 put option. So it got almost double the first leg if it exercised the put option. If it didn't exercise the put option and the taxpayer exercised the call option, or the taxpayer's parent company exercised the call option, then the bank got nothing. So it was the first tier tribunal was entirely right in my respectful submission to say that it was virtually certain that the put option would be exercised at the end of the 3-week period, and so that the blip in the strict ownership of the asset in the Wiseman's hands would come to an end. My learned friend thirdly referred a number of times to the Carreras case because he was reading out the judgments in other cases that refer to the Carreras case. I don't think anyone's actually shown you what happened in Carreras case, but if I could be permitted just to remind you in a few lines what happened in Carreras. It's referred to at length by both the first tier tribunal at paragraphs 212 to 218 and by the upper tribunal at paragraphs 70 to 72. But in that case, it was to do with Jamaican stamp tax, and if you had a reconstruction, if you like, for sold your shares for an issue of debentures, then there was no stamp tax. But if you sold your shares for cash, then there was stamp tax. So what the taxpayer did was transfer its shares to another company in return for an unsecured, non-transferable and non-interest-bearing debenture, which was redeemed for cash 2 weeks after the share transfer. And it was held by the Privy Council, Lord Hoffman giving a speech, that on a purposive construction of the relevant Jamaican stamp tax provisions, the transaction was not an exchange of shares for debentures, but rather it was the exchange of shares for money. Well, as I say, the first tier tribunal set out all the facts, 212 to 218, the upper tribunal 70 to 72, and Carreras is in your bundle at volume 2, tab 33, and if I could just be permitted to read just the very last paragraphs of Carreras. The paragraphs that I would rely on are all red-lined, but it's the last two paragraphs that have caused a certain amount of interest over the years, paragraph 15 and 16. Mr. Goldberg, for it was he, submitted that a factual inquiry into what constituted the relevant transaction for the purposes of paragraph 6.1 would give rise to uncertainty. He was disposed to accept that if Representative Carreras had handed the share certificates over the desk in exchange for the debenture and the representative of Caribbean had then handed it back in exchange for a cheque, it would be hard to say that the relevant transaction should not be characterised as an exchange of shares for money. But what if the debenture had been redeemed a year later? Why should a fortnight be insufficient to separate the exchange from the redemption? One answer is that it is plain from the terms of the debenture and the timetable that the redemption was not merely contemplated. The redemption of any debenture may be said to be contemplated, but intended by the parties as an integral part of the transaction, separated from the exchange by as short a time as was thought to be decent in the circumstances. The absence of security and interest reinforces this inference. No other explanation has been offered. In any case, their lordships think that it is inherent in the process of construction that one will have to decide as a question of fact whether a given act was or was not part of the transaction contemplated by the statute. In practice, any uncertainty is likely to be confined to transactions into which steps have been inserted without any commercial purpose. Such uncertainty is something which architects of such schemes have to accept. And we say, well, it's no answer to say, oh, well, you could have an ordinary financing lease transaction where you might possibly get it back in a year or two. Where would that leave us? That doesn't affect the interpretation, I say, of this legislation in these circumstances. It may well be, I think this takes me on to the next point, that my learned friend talked about Boss Holdings and saying that we and the first tier tribunal were trying to interpret the section 61 by reference to later legislation. I must admit I hadn't thought that we were trying to construe section 61 1A by reference to subsequent legislature. If you have a look at section 61, I've got it at the first tier tribunal. It's paragraph 24 of the first tier tribunal. Let me find it. 26 of the first tier tribunal's decision. There you've got section 61(1)(a), which is the one we're looking at, obviously. The person ceases to own the plant and machinery. B, the person loses possession of the plant or machinery in circumstances where it's reasonable to assume that the loss is permanent. C, the plant or machinery has been in use for mineral exploration and access and the person abandons it at the site where it is used for that purpose. And D, the plant or machinery ceases to exist as such as a result of destruction, dismantling or otherwise. So it's not a question of B and C talking about ceasing in a permanent situation or ceasing in an abandonment situation. they're using the words loss and abandon in the same vein, I would submit, as ceases. So A is ceases, B is a loss, it's permanent, C is abandons, D is ceasing to exist, and as I said in opening, that clearly can't be intended to mean ceases to exist by dismantling if the plan is that you're going to repair all the pieces and put it back together again in 3 weeks' time. It clearly does, in my respectful submission, import a feeling of permanence in this situation. Okay, as my friend says, probably before the finance leasing changes in the law, it hadn't been necessary to actually ask in court what a person ceasing to own meant, because nobody was trying to exploit the rules by having a quote cessation for a couple of weeks in this sort of situation. It's probably true to say that it's only because of the change of the law in 2006 that tax planning schemes came into existence in order to try to exploit this legislation. But nevertheless, just looking at the wording A, B, C, D as they are and as they were enacted in 2001, I do say that ceases has is redolent of permanence, and it's not something just a temporary blip. And indeed, the first tier tribunal, my respectful submission, were entirely right to hold that in these circumstances there was no cessation of ownership. Next point is my learned friend referred to UBS, which I didn't refer you to in opening, as indeed it's common ground. It covers a large number of the cases, but we fully rely on UBS. That is at tab volume 2, tab 40. Hopefully you've got it reasonably handy. We do. I think it's fully black lined. It's 61 to 78 and 85 to 89 in particular. I'm not going to read them now to you, but just for a note, those are the paragraphs in which we rely upon. Just if you've got it there, it's on page 642 of the bundle. It starts as the judgment of the court, read by Lord Reed. Paragraph 1 says, in our society, a great deal of intellectual effort is devoted to tax avoidance. The most sophisticated attempts of the Houdini taxpayer to escape from the manacles of tax, to borrow a phrase from the judgment of Lord Justice Templeman and Ramsey, generally take the form described in Barclays Mercadal Business Finance Limited and Mawson, and we've seen that paragraph. Paragraph 2. The present appeals are concerned with composite transactions of this nature designed to avoid the payment of income tax on bankers' bonuses. You sort of know which way it's going to go, don't you, when you see that? There was a judgment of the Court of Appeal not long ago which said the appellant is a hedge fund manager. One didn't really read to the end. Anyway, we entirely rely upon, not just accept, rely upon everything that's said in the UBS, in particular, all the red lined or black lined bits that if you've got there, I won't read them all out because it would encroach on my learned friend Mr. Davies' time if I did. Then learned friend went to Hurstwood and Rossendale, and of course we read all that to the court on Tuesday. I think it's pages 45 to 63 of the transcript set out all those paragraphs in full, and what we say, I think Lord Justice Nugee asked a question. We say that we can't, the legislation can't have meant us to be ceasing to own in this particular type of situation. My own friend says you can't jump from saying, oh, this is an avoidance of tax scheme, so to saying, oh no, it doesn't work. We're not saying this is to be interpreted because it's avoidance of tax. We accept that we probably wouldn't be asking this question if there hadn't been a tax avoidance scheme attached to it. But I say that you interpret ceasing in the normal meaning in the context of 61, and if you do that, then that has an element of permanence in it, and not the scheme which the first tier tribunal dealt with so extremely well in my submission. So that's, yes. In relation to various other cases like Ensign Tankers, they actually acquired some film rights worth £3.25 million, but not 14 million, which is what they've been trying to get relief on. Similarly, in BMBF, they got a pipeline. In Tower and Cashback, they got software, but they got relief for the amount of money they'd actually spent on the software and not other money that had been introduced into the circle. Here, they got absolutely nothing that they didn't have before. And it's absolutely clear on the findings of the first tier tribunal that that's right. I invite you to agree with the first tier tribunal, paragraph 271, which said, in economic terms, nothing had happened except that the appellants had paid some fees and expenses in order to generate qualifying expenditure without suffering the financial burden of that expenditure. And in my submission, that falls outside the scope of the purpose of capital allowance legislature as explained in BMBF. And I would therefore respectfully invite the court to conclude, as did the first tier tribunal at paragraphs 23, 235 and 260, that on the facts which they had found, there was no cessation of ownership within the meaning of section 61(1)(a). Shall I hand over to Mr. David, or would you have any questions?
Thank you very much. Yes, Mr. Nugee.
May I just have 60 seconds? It's always fun at the end of a hearing when everything comes together.
All falls apart.
Falls apart. I have a number of points to make. I think it's probably going to be in the region of 6 or 7. It's something like that. I'll just work through them. So first point is this. At the beginning of my submissions on ground 2, there appeared to be a preliminary question of whether this court could even hear it at all. I'll note that my learned friend no longer pursues that point, and I say that he's right not to do so. It's the paragraph 38 PTA decision point, and I say it is legitimate for this court to hear ground 2, and my learned friend would appear to agree. Of course, whether the court agrees is another matter, but I say it's okay to do so. Second point, in relation to the required assumption. The learned friend's primary submission is that the required assumption is comprehensive. It is the sole subjective intention that can be taken into account in relation to ground 2. It was my submission yesterday that on the proper reading of that assumption, the proper understanding of how it worked, that wasn't right. I maintain that submission, and I note that Lady Justice Whipple, who I think has a relevant view in such regard, is of the same view. The learned friend then said if he's wrong about that, So if the required assumption is not determinative of the whole question of subjective intention, then in any event, any subconscious subjective intention would be identical, it would be exactly the same. Now, I say fundamentally that's an assertion rather than an argument, but if insofar as it is an argument, then it has to be tested against the facts. And I say the facts speak for themselves in saying that isn't all that was going on. That isn't what one should take from the facts as found. And I made submissions on that yesterday. Thirdly, still on subjective intention, my learned friend said that my case proved too much. He said that if I'm right, then any time a taxpayer has a desire to get allowances, then they fall foul. I say that's wrong. I say that's a parody of my position. Why every single case? I say that that entirely disregards exactly what the Supreme Court said in Tower, Lord Hope at 88, that the extent and depth of the factual inquiry will depend upon the particular case. It's the same potential move that the Supreme Court head off in Rossendale at paragraph 61, where Lord Briggs and Leggett say, essentially, it might be said that the way we've put this is too broad. We'd resist that. We're deciding it on the facts of this case. Paragraph 61. And as I said several times yesterday and again first thing this morning, the key question to ask in this case, if you're asking about the purpose of paying the put option price, is to ask, it's necessarily to ask, why the put option is there at all. That is a question specific to this case. It's not a question that arises in every case. The next point, and I'm broadly speaking taking points in the order in which they arose in the learned friend submissions. The learned friend went to Tower and essentially said, Tower is a case about on. I say that's not right, because at paragraph 80, Lord Walker expressly talks about there having to be real expenditure for the real purpose. He's fully cognizant of the fact that an aspect of looking at section 11.4 involves purpose. What's the real purpose? And it's also, I say, self-evident from the way in which Lord Walker and Lord Hope deal with the case of Tower, that what they're carrying out is an objective, or at the very least, a substantially objective, not subjective, exercise. And I say that does give the lie to the idea that section 11, question of purpose in the context of section 11, is purely subjective. I say that cannot hold water consistent with what the Supreme Court's position is in Tower. Reference in this context was also made to the case of 7 individuals. And the learned friend fairly made the point, which is the same point I made yesterday, which is that it's different wording. But the point I was trying to make is that in 7 individuals, the question of the purpose was being asked of, quote, the arrangements. And in the PI consulting case, which is cited in 7 individuals at 100, the question the legislation asked there was of the purpose of the scheme. And here we're talking about the purpose of the expenditure. And I say that the difference between those concepts is one of degree rather than of kind. It's not asking what the purpose of person X is in doing a particular thing. Arrangement, scheme, transaction, expenditure. These are all things in respect of which it makes sense, logically and as a matter of ordinary language, to ask of its purpose. example I gave yesterday was the military expenditure example, and my submission ultimately was that there might be a number of different ways in which one investigates what the purpose might be, and they may or may not ultimately collapse into the subjective position of someone involved in actually making the money transfer. My learned friend then essentially said, what facts is it that the revenue I want to add in that are relevant here? And in the end, the nub of his submission was essentially, I say, there's a tax motive. Again, I say that is a parody of my position. That's not my case. The key question, which I raised more than once yesterday and again this morning, is to ask, why is the put option there? He missed that out from his list. Why is it there when you've already got an option, call option, which gives you the same rights, with more control, at a lower cost? Say the answer to that, an investigation of that factual aspect of the case gives the correct answer, the one I stated this morning. Relatedly on tax motivation, if my learned friend's submission is that that's always irrelevant, then, as my Lord Justice Nugee explored with my learned friend this morning, it's not clear that that's quite right. There was a discussion about what one does about paragraph 49 of Rossendale, together with paragraph 51. And my Lord Justice Nugee made a suggestion of how one might reconcile things between them. And my learned friend said, it's a fair paraphrase to say that he thought this was all jolly difficult and he wasn't quite sure how they sat together. I say it's not difficult. The answer is actually given in paragraph 11 of Rossendale. As ever in this area, one ends up going back to the source. Paragraph 11 in Rossendale, Lord Briggs and Lord Leggett are referring to the decision of Ramsey itself, and a decision referred to in Ramsey, namely the Gilbert case, Judge Learned Hand. Paragraph 11, Lord Briggs and Leggett say this. The result of applying the purposive approach to fiscal legislation has often been to disregard transactions or elements of transactions which have no business purpose and have as their sole aim the avoiding of tax. This is not because of any principle that a transaction otherwise effective to achieve a tax advantage should be treated as ineffective to do so if it is undertaken for the purpose of tax avoidance. It is because it is not generally to be expected that Parliament intends to exempt from a tax a transaction which has no purpose other than tax avoidance. And then the quote there from Judge Learned Hand: the taxpayer enters into a transaction that does not appreciably affect its beneficial interest except to reduce its tax, the law will disregard it, for we cannot suppose that it was part of the purpose of the Act to provide an escape from the liabilities it sought to impose. It is, I think, fundamentally the same point that my Lord Justice Nugee was making, which is to say, it may not be irrelevant in considering what Parliament's intention is to bear in mind that it may be unlikely that Parliament would intend to allow transactions of the nature described in paragraph 11 to fall within a provision.
Could one possibly argue we're moving perhaps or getting towards a position where there's a kind of rebuttable presumption that in construing acts of Parliament, where there is a clear tax avoidance background or purpose, if you like, the legislation as a whole should not be construed in a way which enables that kind of tax avoidance to achieve its purpose. I mean, I put that in a very general way, but only obviously something that has to yield to any clear contrary provision. Would there be anything fundamentally wrong with something along those lines as a sort of way of trying to formulate what I think many of us sense is still deep down a very important part of the Ramsey doctrine, namely its role in countering egregious tax avoidance schemes?
Well, your lordship raises characteristically a very interesting question. I think it's probably above my pay grade to answer.
Maybe well above mine, even.
But I do, in trying to reconcile this issue of paragraphs 49 and 51 of Rossendale, I do say have a look at paragraph 11, which of course takes one back to the very beginning, which is well, advocates, with the assistance, of course, my own friend Mr. Mill, making submissions to Lord Wilberforce and others, which include some of the learning from America, amongst other places, and we see that learning and that way of thinking. I think that's how Wilberforce puts it, actually, a way of thinking, because he doesn't rely on those American authorities as principled, but as a way of thinking, which has gained currency and is still there today, including in Rossendale, which is the Supreme Court's most recent way of putting it. So perhaps a way of thinking, if that's of any assistance. But
I mean, one's left wondering in Rossendale whether the Supreme Court adopted was, on the face of it, was a pretty adventurous interpretation of a very straightforward provision in the relevant legislation referring to a right to possession, and yet has interpreted that expression in this particular context, far removed from any tax avoidance context, as going beyond the mere consequence of the grant of a lease and its established land law consequences. I mean, I wouldn't normally embark on an inquiry of that nature unless it was sort of prelude to trying to find a way to ensure that these egregious schemes couldn't work.
Well, I think at one stage yesterday, my Lord Justice Henderson referred to a submission I was making as kaleidoscopic. Last night I was trying to work out whether that's whether that was a compliment or something far from a compliment.
No, it was admiration, really.
But I think what we were dealing with is that I was making a submission which, not for the first time in my career, the court was perhaps having difficulty with, but the basic submission was that you have to take cases like Rossendale seriously. When the Supreme Court says you have to think what these words mean in relation to these particular facts, you have to take that guidance seriously, which is why I resist being painted into a corner by my learned friend by saying I'm trying to aim for something general. And also what I'm trying to do is not, and again, it may be that I met with some resistance on this, and if that's the case, so be it. But the way I put it was to say, my learned friend said, trying to grasp at smoke what I was doing. What I'm asking this court to consider is what 11.4 means, what it really means in the context of these facts. And you have my submissions on it, which I'm not going to repeat again. But it was, the way my learned friend put it this afternoon was to say I'd asked what role the provision plays, but I was actually saying what role do the words on, or on the provision of, and purpose play within the context of this provision, within the context of these facts. So I won't repeat everything I said yesterday, but that's what I'm trying to do. Either the court likes it or they don't like it, but that's why I think my learned friend parodies my case when he says, well, what's the facts that he's trying to say are relevant here? Because he misses out the key question, why is the put option there at all? And also it's too swift to say that the aim of the scheme, the clear design, I mean, paragraph 75 couldn't be any clearer in the FTT decision. The clear design of the scheme is to achieve this particular result. Why it's too swift to say that that's irrelevant when the Supreme Court, going back to authority now more than 40 years vintage, clearly doesn't think it's irrelevant. There may be a question as to how you articulate it, whether it's a way of thinking or whether it's a rebuttable presumption or whether it's just a common sense rule of thumb that generally speaking Parliament might try to act in a particular fashion. But the idea that one can just say goodbye to all of that, I should say, should be rejected. I think I've only got, one or two more points. My learned friend said that essentially he had the findings he needed in the FTT decision to show that ground 2 had to fail. Now there's a bit of a, well, possibly a bit of a what sauce for the goose is sauce for the gander point here, because he was also keen to say you've got to read findings of fact very carefully and decide, what the issue was that was being considered. But for the first time, the Lady Justice Whipple was ahead of me by several steps. The final sentence of paragraph 312 sub 3 makes absolutely clear in my submission. My friend said you have difficulty with it, but I say it's plain as day that she's saying I'm addressing this on the footing that one can't view things through the lens of Ramsey, if one wants to put it that way. And the findings referred to, they're actually submissions that are made by my learned friend Mr. Milne. Reference were made to 2962 and 2971. But if one goes back to 293, one can see that this is all in the context of what's called the QA issue, and it's all on the footing that Ramsey isn't in play. And of course, it's my submission, and indeed, I think, on the basis of my learned friend's submissions of today in relation to paragraph 38 of the PTA decision, it's my submission that Ramsey is in play. But if and insofar as it is legitimate to go back to findings of the FTT decision, I won't trawl through the various findings we've gone through before, but if one wants one, it's paragraph 75. It is plain in the design economics of the scheme that the appellant's sole purpose in entering into the various transactions was to obtain allowances on the option price without suffering the economic burden of paying that amount. I mean, we could go through others, and the transcript will reflect the ones I've referred to. But my fundamental point is that there are findings in the FTT decision which are relevant. I go back to what I said yesterday about the fact that the required assumption is meant to add to the jigsaw rather than change the jigsaw. And if one does, and when one does add it to the jigsaw, it's not the answer. The answer is revealed by asking the question, why is the put option there? Why is the put option deed there at all? Unless I can assist further, those are my submissions.
Thank you very much. Yes, Mr. Nugee.
Just in the court's indulgence for 30 seconds, a footnote point. You were taken to Judge Learned Hand and Gilbert.
By reference to
Paragraph
what?
11 of Rossendale.
Paragraph 11 of Rossendale.
Yes, yes.
Paragraph 11 of Rossendale, Lord Briggs and Lord Leggett begin that side because it is not generally to be expected that Parliament intends to exempt from tax a transaction which has no purpose other than tax avoidance. Not generally. That language is also found in UBS. What Judge Learned Hand says, if the taxpayer enters into a transaction that does not appreciably affect its beneficial interests except reduces tax, the law will disregard it. there is a tension between the position in the US and the position in the UK.
Thank you. Well, thank you all very much for some very interesting submissions and no doubt for the work which your teams have also put into the case. We will, as will come as no surprise, reserve our judgments. We will circulate the draft judgments in the usual way, and then they will be handed down remotely in the way it is now standard. As you will be very familiar, the purpose of circulation draft judgments is to enable you to agree, if you can, an order giving effect to our decision, to correct any typographical and other minor errors, not to re-argue the case. It comes, as you all know, with a fierce embargo, which means what it says. Otherwise, we simply, again, thank you for your submissions, and we will let you know the answers in due course.
All right.